And we're back in the Judiciary Committee continuing to take testimony on H534 and H579 relating to retail theft. And thank you very much for being here, State's Attorney from Rutland County. And introduce yourself for the record and proceed.
Sure. I'm Ian Sullivan. I'm the State's Attorney for Rutland County, although I'm from Chittenden County, grew up in Jericho, and got to work in Burlington at one of their retail shops. Ski rack while I was in college, spent a couple of years. So suspect the bikes and the skis look a little different than they did in the early 2000s. But I really appreciate the opportunity to be here and to talk about what I really understand you guys are focusing on, which are repeat retail theft offenders. And I think that focus on repeat retail theft offenders is quite important in terms of what we're talking about. Because when I think about kind of the heart and soul of what being prosecutor means and what it means to do well, is it's discerning between different types of criminal behavior, even though they have the same literal charge. A retail theft can look radically different between a first-time interaction with the criminal justice system by an 18 or 19-year-old than somebody who has 30 or 40 open dockets. And I think doing criminal justice well means we recognize there are differences between these things and how we respond. And I wanted to make that distinction early on in terms of what I said, because the things that capture our memory and our attention can be the ones that are the most aggravated, right? The cases I've done trials in, the times I've tried desperately to get somebody help through treatment and it hasn't worked, either because they're committing more crimes or, God forbid, somebody dies of an overdose. Those are the times that I really, really remember. The times where I will screen a case, I've never seen the person's name before, I refer the case to diversion, and then I never see them again. I don't remember those cases well. If I see the person on the street and they say something, I would try to jog my memory, but that's a good thing, right? It's a good thing that I don't remember because it worked well. And I will say I'm not here to say we have a problem with our one-off retail thefts and the way the system is working in that space. Not here to say that. I do think we have some really pronounced challenges and frustrations in a relatively small number of people committing a relatively large number of retail theft offenses. And I guess I want to talk a little bit about how strange this moment is in our criminal justice system, because I think that plays into some of the challenges we're facing. And I think that's an important backstory in terms of my views of where we're at. So from March of 2020 through September of 2023, the court system was operating under some form of a restricted operation schedule. Totally appropriate, not here to criticize that, but it does have downstream implications. And for people who, and not everybody, right? It's never everybody, but there unfortunately were a cohort of people who started to realize that getting the citation was about all that was going to happen in the near future. And as 2 weeks at home, 2 months at home, 6 months at home, and whatever the lockdown period was, kept kind of extending out, the prospects of any real consequence for misdemeanor level offenses stretched out into the distance so far that it became almost illusory for a lot of people. Certainly read quite a few affidavits where people have said things to the police like, just give me the citation and let me go on my way. Kind of being brazen about, broke the law, there aren't any consequences, let me get on with my life. That's concerning on some level in and of itself. And certainly many of us who work in the criminal justice system have been worried about how the backlog was building up long before the courts fully opened up again, right? We're seeing our caseloads just tick up and up and up and up without any realistic prospect for many of those months and even years of them going down. And I believe in other settings, you guys have gotten information about what's going on to try to work through the backlog and that progress is happening. It is happening. It's absolutely happening for Rutland County since the judiciary has been pushing out monthly backlog snapshots. Our over disposition guideline cases have cut by about 870, which represents, I think, roughly 43% of the cases from March of 2023 through January 1st of 2024. So we're making progress. We've obviously still got a long way to go. It's not something I would say is a good situation, but we're making progress. But I guess shifting towards more specifically the repeat retail theft environment, I view our role in addressing these cases as trying to discern between different types of cases. I'm not here to say there is a one-size-fits-all approach, right? Not everybody should go to diversion. Not everybody should get the maximum sentence. Either of those approaches would be inappropriate. They wouldn't take into account the facts and circumstances of each person. However, I think the statutory frameworks we have to address those crimes reflect society's values and the seriousness of the offense types. And having tools to address the harm, very important. I think for me, diversion is one of our regular off-ramps. But when we see repeated conduct or things get kicked back because they're inappropriate for diversion for one reason or another, we need to have other tools. I and I think many of my colleagues really liked having work crew as a response for repeated misdemeanor retail theft. Myself, the Chittenden County State's Attorney, the Washington County State's Attorney, and the Windsor County State's Attorney all signed on to a letter together asking the Commissioner of Corrections to reconsider what we believe was a poorly considered and harmful decision to unilaterally remove work crew as a sentencing option because
When did you send that letter?
May of last year. Once we got the Department of Corrections letter, we started typing. Because it limited our options. And quite frankly, having somebody on probation with a string of low-level offenses means they are likely going to get telephone supervision, which is going to distract that probation officer from meaningfully engaging with higher risk individuals. And it's not always a particularly meaningful form of supervision, which categorically I'm against meaningless supervision. It's not good for the community and it's not good for the offender. It's not good for victims.
What type of supervision did you?
Meaningless.
Okay.
Yeah.
That's what I thought you said.
If the form of supervision is just calling in and saying, I'm not committing any crimes, and that's supervision, it's not really doing much. I would far rather have those probation officers working with people who pose a very real risk of violence in the community, working on rehabilitative efforts, or working on actually supervising to make sure that they're not engaged in risky behaviors. Far rather have that going on. Work crew was a relatively short period of time, no more than 15 days at the time the program ended. And it provided some very real certainty. Somebody would be working at some form of community restitution in the community. And if they didn't show up, there was a return on minimus and they would serve the sentence in the correctional facility. And for low-level crimes where really the message we are hoping people will get is don't steal. And if you do, there will be consequences. That was a good intermediate step. For folks who accumulated even more cases, as Mayor Dunn just testified to this committee about, frequently those folks were also experiencing substance use disorder, and those criminal behaviors were taken to fuel their desire to get more drugs. Where someone is amenable, once they've accumulated enough charges, quite frankly, we, or at least I believe, using something like treatment court can be incredibly effective because while there should be consequences, the consequence is only as good as the future, right? So if the consequence by itself doesn't stop the behavior, the rehabilitative aspect hopefully does. So something like treatment court where people really have a choice of remaining at liberty in the community if they're fully engaged in making progress, or a traditional criminal justice response if they disengage, I think can be an incredibly powerful tool. But that's not going to work for everybody. It is significantly harder than being on a probation sentence. It's quite frankly, in many cases, harder than being on a furlough sentence. So if we have somebody with 3 or 4 misdemeanor retail thefts, they would have to really want to do it by themselves, because their defense attorney would likely tell them, hey, if you go in and plead in front of the judge, the implications to your liberty are going to be less than engaging in treatment for it. And I wouldn't disagree with them. That is an accurate statement. So for somebody in this repeat retail theft space, it is usually when they either accumulate an astronomical number of charges or where they cross the line into felony behavior. Certainly, I listened to several of the retailers' testimony, and those interactions where somebody is confronted by a retail worker and then things become physical. It might be a retail theft and a larceny from a person, or a retail theft and an assault and robbery. And those are the types of things where the potential sentencing, if somebody is convicted, is enough of an incentive that they want to engage in treatment for it. And I recognize that. I absolutely recognize that. So I guess I will shift into what I have kind of understood as the 3 questions that I think this type of legislation is trying to get at. 1, do we have a problem? 2, what legislative responses are available? And then 3, I think the through line I've heard today and in other testimony is, what implications will that have for the backlog? I think to the first question, do we have a problem? I think the answer is yes. Since the beginning of December, I've got 2 anecdotes, and I want to be very clear that these are they are 2 people. They are not the whole criminal justice system, but they're 2 people. But they are 2 people who occupy quite a bit of law enforcement resources, our resources, and we're just creating a lot of havoc within the community. And so I'm not going to use names because I'm not trying to vilify these folks. I just want to share some of the circumstances. So the first person had 38 pending dockets with us in Rutland County. Many of those dockets included multiple charges. Additionally, had 2 dockets up in Addison County. At the time this person was sentenced, he represented more than 2% of the active cases in Rutland County. One person, right? We're a county of 60,000 people. Yeah. Oh, sorry.
38 dockets you said he had in Rutland
Yes.
City?
Rutland County.
Rutland County.
Most of them were the city, but yes.
How many charges is that?
I could count it up for,
100, but that's just.
it was the plea agreement, I think, ended up being 12 pages, and we dismissed an appreciable number of cases in reaching the ultimate disposition. Ultimately, the accumulation of charges stopped when this person stole a gun out of somebody's truck. We had state court charges we could bring, as probably I imagine you are all very well aware because it's a recent law, probably came out of this committee if I had to guess. Vermont's prohibited person in possession of a firearm is a misdemeanor. It is a misdemeanor. The federal version is a very serious felony. The federal government stepped in. They detained this person. Ultimately, he pled guilty in federal court, pled guilty in state court, federal court, sentenced to 33 months. They have determinate sentencing. They have indeterminate sentencing. So 33 months followed by 3 years of supervised release to resolve these 38 dockets in Rutland County, many of which included retail thefts from the same establishments, unlawful trespasses, where those businesses had tried to protect themselves by issuing a no trespass order. Ultimately, he was sentenced to a concurrent sentence of 33 months to 7 years, meaning that the minimum sentence between the federal and state were identical, but there was a prolonged period of what is furlough eligible supervision in state court. The second person, and I should say, that first individual earlier on in the accumulation of charges had been offered the opportunity to participate in a treatment court. Ultimately, the last event before the federal government detained him stealing a gun, loaded gun, for the purpose of what he told the police was to sell it to obtain more drugs. That certainly can have horrific implications, right? Guns being traded on the black market in exchange for drugs poses the very real risk that that gun is used to commit an act of violence.
I just really appreciate the actual stories, because I feel like
Sure.
it helps to see the different decision points and where
Yeah.
things are at play. And so this was a question I had, but I'm going to maybe just use it in this example
Sure.
to see. So you're saying that once this gun was taken, it initiated, not at the state level, at the federal level, that it was a felony, and so brought this person into the court system, and then everything could kind of go from there.
Can you try asking that a different
His,
way? Yeah.
that his charges were all like able to be addressed is what it came to be. Like these were all pending, sitting there before, but there wasn't something that pulled it to be like, okay, you're now a priority and we're going to address all these things.
We had certainly been trying to resolve the cases before that.
So what I'm just trying to understand what it was about the federal felony that got to everything came to be.
Oh, sure. So certainly there are far fewer cases in the federal system, and he was detained in the federal system. Put somebody on the fast track to trial in our system. I assume it's the same in the federal system. And once there was a federal resolution, there was no. Let me back up and say that in the federal sentencing guidelines, the number of convictions someone has before sentencing plays into the type of sentence they get. So once somebody is facing a state and federal charge, there is usually a huge incentive for them to delay adjudication of the state cases until there's been an adjudication of the federal cases, so that it does not, so that they have not been adjudicated of the state cases first. So once the federal case was over, that incentive no longer existed. So it was a good time to talk about resolution.
Okay. Because I'm just, so maybe this is appropriate for my question is there the possibility at any time for a state's attorney to just see, like this is a repeat offender, a person that has 30 dockets, and just say like, okay, we're having this person be addressed. Like this is going to be a priority out of all the cases. Like, is that a possibility that's ever on the table?
So my perspective is that the court decides which cases, the scheduling of cases. We can certainly ask, but the reality is it's not just retail thefts that were backlogged. I will make no apologies for prioritizing trying homicide versus retail theft, even if there are 30 retail thefts. I'm absolutely going to choose trying to prosecute the homicide first. An interesting feature of Vermont's criminal justice system is that we have essentially a one-track criminal justice system, whether the person is facing a charge for stealing a six-pack or aggravated murder. Their hearings could be scheduled back-to-back. I'm also licensed in Massachusetts, although that license is collecting a lot of dust. And not a lot of spare time to break wheels in Massachusetts. But they have a district and superior court approach where either cases that are misdemeanors, and I'm reaching really far back in my memory for this, but so I recognize the possibility that I have to correct this at some point. Cases that are misdemeanors or where the prosecution commits to seeking less than a certain amount of jail are handled in district court with expedited rules of procedure, whereas felonies or those felonies where the prosecution says, well, no, we're not restricting ourselves to a certain ask at sentencing. Those will be handled in superior court. And that allows for the superior court to focus on some of these more public order, quality of life crimes, because they're not competing with an aggravated assault or a homicide or a sexual assault for trial days. They've got dedicated trial days for themselves. And in Rutland County, years and years ago, pre-pandemic at this point, when Judge Hoare and Judge Corsones were presiding in civil and criminal court, respectively, Judge Hoare, through the magic of the judiciary, was dedicating a separate jury draw and trial days from the civil court calendar to misdemeanors where the government was either seeking a fine or not seeking jail time. And that meant that some of our retail thefts, our unlawful trespasses, our DUI ones percolated to the top of trial lists faster. And at least from my perspective, that really helped us move some of those cases. And because I think that's part of this, right? For the public, for folks who are perpetrating crimes, the certainty of conviction on some of these retail thefts is relatively high. I'm not trying to shrug my burden of proving things beyond a reasonable doubt. Most retail thefts, they're on video, right? It is the date of trial where it is a near certainty that usually spurs somebody to talk about resolution. So having that expanded capacity to get to trial dates in a meaningful way. If you're 300th on the trial list, that's not meaningful, right? It is not meaningful, especially if there's 5 days, right? It's just not meaningful. My dream world would be an increased capacity and other things. I suspect that even if tomorrow the criminal justice system doubled in capacity for trials, it would take just about everybody in the system, the judiciary, the public defense system, and the state's attorneys, quite a while to fill those spots. I take hiring prosecutors very seriously because I want them to bring experience and judgment, discernment to all of their work. The idea of hiring somebody who doesn't do that well, there's plenty of things that keep me up late at night and make me worry. That's one of them. I don't know if that actually answered your question. I'm sorry. I might have gone off on a tangent there.
It was very helpful. I'm trying to think about, how can we address this problem? And I appreciate that, because I think we've heard some testimony of that judges and state attorneys can kind of huddle and kind of talk about, okay, these are the priority cases of what are going through. And so I'm like, well, why can't these be the priority cases? And I appreciate if you have a homicide or some other thing like this, it's hard to put this above that. But I feel like these are some of the things for us to consider. If the trouble is getting things through the system, like I'm worried if we just call something a felony to get it to the top of the list. Okay, so that's getting it to the top of the, but are there other ways we can do that without adding the known impact that we have of labeling somebody with a felony?
Yeah, and I guess this is my own personal philosophy. It's certainly not speaking for the other 13 states attorneys. I think the crime research group data that all of you got is somewhat consistent with my thinking, which is even when we have felony retail thefts, the sentences are, when there are jail sentences, they're rarely longer than the 2-year felony cutoff in Vermont. What that means to me is that when I'm approaching negotiating a case, I should think long and hard about whether something needs to be a felony if we're not pursuing a felony sentence. There are times when I think the answer is yes. And I'll just illustrate that. Right, there are collateral consequences that go along with a felony conviction. Most, from a public safety standpoint, to me, most notably, the prohibition on possessing a firearm. There are times when somebody is dangerous or concerning enough where I think the felony conviction, because it triggers that prohibition, is really important, even if we are not seeing a felony sentence, meaning something longer than 2 years. The rest of the time, the collateral consequences of a felony, I don't want to say always, but regularly, I'm willing to dismantle a felony to a misdemeanor if it means that we're getting to the right sentence. Because I mean, not in Vermont, but in other places, a felony conviction means somebody can't vote. And well, as a human being, I don't like that, but I can't control what other states do. But I recognize that people who are in Vermont might not always be in Vermont. They might want to be somewhere else. And if we're not looking for a felony sentence, I'm usually willing to dismantle it unless there's some other compelling reason. So I hear that concern, and in many ways share that concern, maybe with slightly different permutations, but I share that concern. Hopefully now I've actually answered your question.
Yes, thank you. I really appreciate it.
And I guess I do want to talk about the second example that I took some notes on before coming in today, because it's a slightly different path. So this second person, as of May of 2023, had 10 pending dockets, multiple charges within many of the dockets, retail thefts, unlawful trespasses. In May, he was given the opportunity to participate in our treatment court. He took that opportunity. And I just want to pause on treatment court to talk about not only my office's support, but the broader community support. I saw Representative McGuire in here earlier. Probably you all know that his other job is working at the dismissed house. He has helped get beds dedicated to the treatment court. That type of stabilization in a living environment, in a sober living environment, is so meaningful for people when they're just starting out. And the other really impressive community support we have is from the Rutland City government. And that really plays out in a couple of ways. One, they have dedicated a police officer to being there. And from my perspective, not just any police officer, but somebody who is fully invested in the success of participants. Will check in, say hi, encourage people out in the community while he's doing, his other job, but he's showing up at the treatment court sessions. We also have regularly the chief of police and the mayor stopping in for the public portions of treatment court. And, I've heard people say that addiction is really a lack of connection. And hearing from people in positions of authority that they are proud of the progress people are making is so very meaningful. And in my view, for folks whose crimes are driven by substance use disorder, a lasting, durable sobriety is one of the best public safety outcomes we can achieve. And so having, not just the judge it's their job to be there, the prosecutor whose job it is to be there, but members of the police department and the mayor's office show up to show that the participants in the program are members of our community and that we're all cheering. There is that's the warm and fuzzy part of it. There's also consequences, accountability responses, jail sentences if things are not going well. But that level of support, I think, is incredibly meaningful. I would be remiss if I hadn't said that. But for the second person, unfortunately, diligent efforts, we are dealing with humans and human circumstances, and nothing's 100%. It unfortunately did not work for this person. And between entering treatment court and when this person's case is ultimately resolved in the middle of December of 2023, we got an additional 11 dockets, include multiple charges in a number of them. And when all of these cases ended up resolving for the second individual, the restitution judgment orders totaled over $16,000. And to me, that's a lot of money. But I think it's important to focus on what a restitution judgment order actually means. It is an uninsured material loss, meaning if the store recovered the goods, there wouldn't be a restitution judgment order. If the store was insured for that loss, there wouldn't be a restitution judgment order. From my perspective, that's huge. And I think highlights the type of economic impact that a single person who is engaged in these repeat behaviors can really have on a relatively small geographic area. And in both of those cases that I was talking about, they are extreme cases, and there were punitive responses. and they happened eventually. It's the eventually that worries me most, because I think you have all heard a lot of the clamor around this issue. I certainly have. I think at least a couple of you joined me and Mayor Dunges at the Paramount in November and heard loud and clear from members of our community how frustrated and upset they are about some of these issues. I'm not here to suggest that just because there is clamor, there should be a response. But the thing, like I said, there's lots of things that keep me up late at night. Unsolved homicides, complex trials, the regular legal work of being a prosecutor. But the one that, quite frankly, worries me the most is if people lose faith that our system provides meaningful accountability and start taking the law into their own hands. Certainly, there have been rumbles of that across the state, people forming ad hoc citizens watch groups, patrols, or intervening when they believe someone is committing a crime, and just observe generally that the difference between a citizen's arrest and vigilante justice is uncomfortably close. And so I think when I think about working in this system, that providing accountability that is meaningful to our communities is really something that we should be concerned about on that front, so that those trends, well-intentioned as they are, don't continue, don't escalate. And so that's is there a problem piece? I would say yes. I would say yes. And so I want to talk a little bit about, very fast. I will talk very fast. I promise I can talk fast about potential legislative responses. First and foremost on my list is reducing time to disposition. Largely that is a feature of capacity. Recognizing that might not be the best or easiest thing for you guys to do. Talk about some other potential responses as well. One is to give us sentencing tools that provide differentiated responses. Work crew is at the top of my list for that. Then I think giving us statutory tools that would reflect repeat offenders. There are examples within Vermont law currently of where this happens, kind of reflect society's desire to respond to repeat behaviors. One is in the violation of an abuse prevention context, where there's and in the domestic assault context, where there's an existing court order designed to protect someone. Repeated conduct in violation of that order gets an enhanced response. I'm not saying that inherently has to be a felony for the reasons we've talked about, but I can imagine a system like our misdemeanor DUI system, like our misdemeanor DLS or DUI system, where a second offense in violation of a court order or a notice against trespass triggers some sort of a misdemeanor response with a statutory minimum. In the DUI 2 context, that's 60 hours of incarceration or 200 hours of community service. That would be a step towards reflecting the increased severity of violating court orders to repeatedly victimize businesses. I think that could happen with conditions of release, with no trespass orders, or it could just happen if there's a prior retail theft conviction. Those are all options available to the legislator. Certainly felonizing serial retail thefts has some logical force to it. I recognize that victimizing a business by stealing $900 is in many ways worse than stealing $100. I don't understand why it is necessarily less bad to steal $900 over 5 incidents in a week than it is to do it all at once. Repeated victimization to me seems like it is more harmful writ large. So I think there is some logical force to bundling, if as it were, those harms when they have a similar aggregate value, although that is largely a policy decision. I think in many ways
it's a policy decision, but I want to understand
Sure.
from a practitioner,
yeah,
it will help.
Yeah, so certainly I will just observe that felonies are usually the thing that provides enough incentive for somebody to engage in treatment court. It's very rare for somebody on all retail theft misdemeanors to say, yeah, it's worth it for me to engage, even though they have the same sorts of problems as somebody facing a felony charge. I'll just shift very quickly.
Don't worry about the bell until
Okay,
somebody
cool.
knocks on the door. We'll just.
Okay. So just very,
Announcement out there.
very quickly,
Take a minute.
on the backlog piece of it, felonies in Vermont have the right to a deposition. I heard from some of the other witnesses that may slow down the process. From working on many felony cases over the better part of a decade, defense attorneys, while they have the ability to take depositions, rarely do it if the contested issues in the case are caught on video, right? We see this in DUIs all the time, right? A DUI 1 versus a DUI 4, misdemeanor versus felony. There will be depositions usually about the things that weren't captured by the camera. In the old systems where it was just straight ahead, if something happened over here, taking a deposition about that. I get that. That totally makes sense. But most retail establishments have great video systems. So the deposition would really be like, hey, do you have a video system? Yep. Does it work? Yep. Was it working that day? Yep. Is that your stuff on the shelf? Yep. Is that the stuff leaving your store? Yep. Did anybody pay for it? Nope. How do we recognize the person who took it? And that's the whole deposition. And I suspect that we wouldn't do many depositions like that because it's captured on video. For the retail thefts from a store that doesn't have a video system, I would expect we would do depositions in that space, and that would take some time. I recognize that.
So as far as legislative responses, one is dealing with the backlog. Certainly understand that, and that I wouldn't look at dealing with the backlog as speeding up the disposition of cases, and that could involve a different prioritization that the courts implement if there's repeated misdemeanors or whatever. Work crew, which we're working on with corrections right now, treatment court, which is part of the court's ask in dealing, getting some additional resources there. And that this is also, in your view, an additional tool that could be used in certain circumstances for the reasons that you stated. Did I sum that up?
I think that is a very good summary of what I tried to jam in those few minutes.
Yeah. And did you have, I thought you said you had 3 points, and I can't remember what the third one was.
Whether it would impact the backlog.
Oh, thank you.
I hope I covered it.
And that one, it sounds like maybe not. I mean, you're taking away 5, 6 possible misdemeanors, adding a felony. How does that wash out?
I don't think that would. I think the raw numbers would not have a huge difference on how quickly cases moved. You're dealing with the same fact patterns underlying them and coming to grips with what the government can prove, what challenges we have, what legal issues we have in terms of whether evidence gets suppressed or not. Those are going to be the same, whether it's 5 separate dockets or one aggregated.
Right. So, but if it's there's this issue, if it's a felony, if the courts are watching their disposition standards, they say, we have 365 days to get this done. If it was misdemeanors, it'd be 180 days, even though we have a lot of misdemeanors that are 3, 4 years old. So maybe that's a wash, at least where the courts are now. I don't know.
So I think that would be a wash where the courts are at now. Certainly if a response was to create a fast track misdemeanor court and the legislator passed a expedited set of procedures and tacked on a statutory speedy trial right, I could imagine that having a very real impact if the repeated retail theft remained within a misdemeanor context or something like that.
So now this is a question that's kind of off the left field perhaps, but so concerned about felony record, presumably even if there's an aggregated felony, that you add that up, you could still end up making it a misdemeanor in the end. That's part of the plea bargaining. And I guess one question is does that help with plea bargaining? And I have a second. That wasn't my out of left field question. I thought of that one as I was coming up with my other question.
Yeah, I mean, reducing a felony to a misdemeanor is regularly a point of negotiations.
So the other is if we're going to be doing, presumably, we are planning on doing a sealing instead of expungement bill, where we will be expanding the offenses that can be sealed. And presumably this will be one of them if in fact we pass this. an aggregated or theft, felony theft period could be. Does that allay any of the concerns as far as the long-term impacts of?
Love sealing, have concerns about expungement. It's always a little awkward.
We'll say ceiling.
Ceiling.
We have to have that part of the argument. We're looking
Sure.
at ceiling, so.
Sure. Ceiling's great. As long as we can access it in the context where it would be meaningful to the disposition of the case. Ceiling is great.
We did add that. You managed to get that part in. So Tim is
Well,
going
I'm a lawyer, right?
to get that. Any other questions before we're called to the floor or made to go to the floor, I should say?
Or answer the call that.
Or answer the call that we already said. Thank you very much. I really appreciate it. And maybe we'll get you back on the pre-charge, even if it's by Zoom, and even if it's for 10 minutes.
I like doing things in person. It's very